I'm the owner of BarWinners, and we're going to talk to you tonight about how to prepare for the bar, how to study for the bar, how to write a passing bar exam answer, how to structure your essay, and I'm also going to do torts and a torts approach. You should review for this video. You should have your approach book open, and you should be on essay preparation, which is under in the approach book. How to start studying. So let's talk about right now how you pass the California bar exam. What are the keys to passing the California bar? Step number one, if you are a first-time taker, you should be preparing your own outlines based on the BarWinners outlines. In other words, if you are a first-time taker, you should use our outline to determine how you are going to write every issue that's tested on the California bar. In other words, our outlines are a template of what the graders are looking for when that issue is tested. So, in order to pass this bar, you need to study the way you're going to write it. In other words, you have to pre-plan how you are going to write each issue for each question, for each set of facts. You should walk into this bar exam already knowing if the issue is negligence, exactly how you're going to write it. If the issue is easements, exactly how you're going to write it. So we give it to you the way you need to give it to the bar examiners. If you are an attorney applicant who is not taking the multistate, or you are a repeater, you do not need to remake your own outlines. You will use my outline as your outline. You will highlight and memorize from my outline. If you are a first-time taker, you need to make your own outline. You need to synthesize it, condense it, and make it your own. Step number one is that, again, you need to outline each subject, each issue, exactly the way you're going to write it on the bar. That means that when you get to the bar exam and they test an issue, you already have the template. This bar exam is a standardized test. It's like the Department of Motor Vehicles. In fact, it's the state of California. So the point is, when you go to the DMV and they tell you to parallel park, they want you to parallel park. California bar examiners tell you what they want. We show you what to give them. Your job is to give it to them. Does that make sense? And how do you give it to them? You give it to them because you study it the way you're going to write it. You're making templates. You're making canned answers. So when you get to the bar, you're not reinventing the wheel. So, if you're a first-time taker, you need to make your own outline per subject. If you are a repeater, you need to have a highlight and structure your exam and your information and the content exactly the way we have it in the approach book. So, the first step to key to preparing to pass the California bar is to study it the way you're going to apply it. You're going to study it the way you're going to use it. Otherwise, it doesn't matter. We're not testing. The bar is not testing your comprehensive knowledge of the substantive law. They're testing, can you give them what they want? So, to make your own outline or to use the approach book as your source outline, I want to go over how many days you should spend per subject. Okay? So, torts, 4 days. Either to make your own outline of my outline or to highlight my outline and to get the structure and the format of each issue, how it's tested. Contracts, 4 days. Remedies, 2 days. Evidence, 4 days. Business associations, 4 days. Professional responsibility, 4 days. Professional responsibility is the most heavily tested subject on the California bar. I guarantee you your bar will have a professional responsibility question. 1, if not 2. You must know PR. Real property, 4 days. Criminal law, 3 days. Criminal procedure, 2.5 days. Civil procedure, 4 days. The California bar examiners have been promising a California civil procedure question for 3 years now. I do expect it on your bar. Constitutional law, 4 days. Community property, 3 days. Trusts, 2 days. Wills, 2.5 days. Now, sometimes for repeaters always say to me, I spent all of my time last time learning the law, and I didn't spend any time applying it. That is not how we roll at BarWinners. You're going to spend as much time learning the law as you spend applying it and delivering it and figuring out how to give it to them. So, what you're going to think about is that you're going to schedule, we're going to talk about how you're going to make a study schedule, but what's going to be part of your studying every day is outlining, is multi-states. For multi-states, we want you to do 15 MBEs in the morning and 15 MBEs at night. We only want you doing multi-states in the subject you're studying. In other words, if we're starting with torts, we want you right now to do torts multi-states. I don't want you doing mixed multi-states until you have substantively studied those subjects. Because if you do mixed multi-states, you're not going to have the content you need, and it's going to freak you out. So the best way to do this in the beginning is to do multi-states in the subject you're studying. And in fact, I even want it more specific than that. If you are studying negligence, I would like you to do negligence multi-state practice. That way, you study, you do multi-state, you test and see what you know and what you don't know. For multi-states, if you miss a multi-state, we want you to make a flashcard. And the sample of how to make the flashcard is in your approach book, and it's in your preparation for studying for the bar exam. So, 15 MBEs in the morning, 15 MBEs at night. Some people recommend for the multi-state that you do 5 multi-state questions and then you look up the answers. You make your flashcard, then you do 5 more. You make your flashcards of missed multi-states, and then you do 5 more. Some people recommend 15 at one time. Look up the answers, make your flashcards, 15 in the afternoon. Every single day, you need to be outlining, memorizing, doing multi-state and multi-state flashcards. And then, the second trick to this, step 1 is outlining, or making your outline, or highlighting the BarWinners approach. Step 2 is memorization. It's much easier to memorize when you've created your own outline and when you've worked with the materials. Many bar review courses have you memorize the last 2 weeks. That's a disaster of epic proportions. I want you outlining, taking multi-states, and memorizing in short sections. Now, memorize is, let's say you've just outlined negligence. I want you to memorize the elements for negligence. Then I'd like you to do negligence MBE questions. Then I'd like you to look at one of the homework questions we give you, or a study group question, or a home study question, and see how they test that issue on the bar that you've just memorized. So the whole trick to passing the California Bar essays is outline, memorize, MBEs, and apply to questions. Anybody who's in here that's a repeater will tell you they did not do enough questions when they took the bar. They did not do enough simulated exams. They did not do enough application. That's all about to change in this course. You're going to be applying what you're learning every day. Now, after you have outlined, after you have done multistates, after you have memorized, the next trick is, how do you apply what you've just learned? So what I want to go through and what we're going to do tonight is I'm going to show you how to make that 15-minute outline of an essay exam question. The key to passing the essays in California is the first 15 minutes. Your entire future depends on the first 15 minutes of a question. Almost nobody knows how to outline a question. How many of you outlined in law school? How long did you take to outline? But I mean, outlining a question, an essay question? Half the time. How long did you take outlining an essay question? Three-quarters of the time to write. That's good. How about you? How long do you outline? So he's outlining 10 minutes. How about you, Lance? 10 minutes. How about you? 15, 20. Okay. The key to passing the essays on the California Bar is that 15-minute outline. I want you outlining for 15 minutes. Not 5 minutes, not 20 minutes, and not 10 minutes. You're going to get oodles of practice for every homework question that's for in class, every study group question or home study question in making that 15-minute outline. Because if you have a good 15-minute outline, all of you are smart enough and good enough writers to write a good essay. If you've got it in that outline, you can write it. I know you can. So, the key to outlining a bar exam essay is to hold your sheet of paper going this way. You're going to take, and you should hand write your outlines. Everyone should hand write their outline of exam questions. All homework questions, all simulated exam questions, all study group questions. Hand write your outline of the 15 minutes question. Okay? I would not do it on computer. It's hard to look at, it's hard to connect to. So, the number one key to passing the California Bar exam is, number one, learn it the way you're going to write it. So it's a template, and you just fill in the facts. You've got the headings, you've got the structure, you've got the subheadings, you've got the rules, and all you're going to have to do when you take the California Bar is fill in the facts. I've done all the work for you. I have written in this approach book, I have written every question for you. So you need to learn from this approach. You need to use the headings from this approach, the subheadings from this approach, our rules of law, and all you have to do is fill in the facts. It's not very hard. I've done the work for you. Now, if I give you the structure, and I give you the headings, and I give you the subheadings and the sub-steps, you have to use what I give you. And it's not that I'm giving it to you, it's where have we gotten this from? We have of me writing what the bar's looking for, what they give points to, what they have traditionally liked, what order, what structure, what format. We basically took from the grading sheets from the California Bar, from what the graders use to create this book. So we're going from what they want backwards. That's phenomenal. So, the first time you get to a bar essay, one of the things you're going to do on your columns is you are going to repeat the call of the question. You are going to retype on an essay the call of the question exactly. A lot of students say to me, and a lot of attorney applicants say to me, why do I have to retype the call of the question? You retype the call of the question because it immediately lets the bar examiner know that you are addressing what they're asking. They can find you in their grading outline check sheet. Second trick to pass in the California Bar, you are always going to number exactly the way the question numbers. If the call of the question says, number one, what are A's rights against B? You're going to say number one, A's rights against B. And let's say the second call is, what are B's rights against C? And the third call is C's rights against A. Always, always structure your 15-minute outline based on the call of the question. Keep the number, keep the name, keep exactly what they've asked. And we're going to do a question tonight, and I'm going to show you. Why do you have to follow this roadmap so carefully? You need to follow this roadmap so carefully because if your grader gets up to get a Coke and comes back to your essay, they're not going to be able to find out where you are if you're not numbering it the way they want it. This is a standardized test. It's format over content. So much of passing this bar is about structure. How long do you think they take to grade your essays? Anybody? One student says 20 minutes. One student says 1 to 3 minutes. The California Bar examiners spend a minute to a minute and a half on each essay and 2 to 3 minutes on your performance test. Okay? That means that your format, your headings, your structure, your layout is critical. When they get to your exam, it needs to match what they're looking for and what's on their grading sheet. I give it to you, you give it to them. Okay? We're going to make this easy for you and less overwhelming. And truthfully, when I read an exam, I know the grade in the first 30 seconds. When our former bar graders grade for BarWinners and read your exams, they know the grade in the first 30 seconds. So, we're going to be really strict with you on making sure you follow the format, the structure, the approach, and what they've asked. Let's talk a second, while I'm on this, about what these grades mean. Okay? What do you think a 55 on the bar means? Anybody? That's right. The student just said a 55 on the bar exam means you did not answer the question. 55 means they gave you something and you talked about something else. Why would a student do that? Why would an attorney do that? Why did some of you do it? You do it because, number one, you want to write about what you know about, and you're worried you don't know what they're asking. Two, you weren't in a good bar review course that showed you how to read the calls of the question to figure out what they want. And three, you weren't listening to the question. Because a 60 on this bar means that you answered what they asked, but you did a poor job of it. Missed issues, missed sub-issues, didn't discuss facts. Any score in the 50s means they asked you about red and you answered about blue. Okay? You have got to answer what they've asked, and we're going to help you do that. We're going to help you with all of this. You're going to become pros after this. So not to worry. What does a 65 on the bar mean? 65 means pretty good issue spotting, pretty good law, not enough sub-issues, not enough sub-levels. Kind of you got to level 1, got a little bit to level 2, your answer lacked depth. And you didn't use enough facts. Every fact in a California bar question has to be used in your exam, other than some just basic background information that they give you. You have to use every fact. So, how do you write a good bar essay? Number one, you lay it out exactly like the call of the question. Do not make this a number one. If they ask for one, don't put it as Roman numeral 1. If they say little a, you do it little a. I know it sounds crazy, but they figure if you can't follow their basic numbering, you're not going to give them anything. Okay? Now, always head note your issue. If the first issue is negligence, you're going to type it. Are all of you laptoping? If you are laptoping, you're going to have this as a heading. You're going to skip a line under this heading. If you're handwriting, you're going to print, center, and underline this on your exam. I don't mind if you don't center it if you're laptoping, but I want this typed out, I want it underlined, and I want air, space. Because why? You don't need to say, at issue here is whether A can sue B for negligence. All you need is the head note, negligence, boom, done. Okay? Don't bother with issue statements. They're a waste of time and there's no points. The heading is your issue. What comes under this is the rule of law. Under your head note has to be a rule of law. In order for the plaintiff to recover in negligence, she must show duty, breach of duty, actual cause, proximate cause, and damages. That's what you're going to write. Then you're going to head note duty. To whom is the duty owed? Breach of duty. Actual cause, proximate cause, damages, and defenses. As soon as you see the issue, you're going to give them the BarWinners structure under that issue. Do not change our order. Do not change how we lay it out. We are giving it to you the way they want it. So as soon as you see the issue of negligence, head note your elements and leave error. Okay. All right? This bar exam, so after you write your issue, after you lay out your elements, the next thing that goes in are the sub-rules to these elements. Why people fail the California bar is that they don't have sub-issues, sub-rules with sub-facts. They don't do the IRAC within the IRAC. Does that make sense? They do the big issue. They do negligence. They do duty, breach of duty, whatever. But then what you need to do is you need to have the rule under duty, and then the facts get applied to this sub-rule. Okay? This is where the points are on this exam. And under each of these headings, after you write the sub-rule, then you're going to write the facts that go to that sub-rule. When I grade bar exams, what I see missing is depth of analysis under the sub-issues. That accounts for most of the scores that are 60 and below. Okay? Now, you don't need to be in depth. You don't need to be erudite. You don't need to be creative. You just need to give them the rule, and then you apply the facts there. Okay? And I'm going to go over a question tonight and show you how to do this. Okay? But I want to give you the idea. Now, this is the big IRAC, negligence, and whether negligence applies. But the mini IRAC, this is a separate issue, rule, application, conclusion. Issue, rule, application, conclusion. Each element is a mini IRAC. Okay? So, this heading, duty, is the issue. The rule is that everyone owes a general duty to act as a reasonable person would in like or similar circumstances to avoid unreasonable risk of harm. Special duty, checklist is special duty. Then the application are the facts that go to this issue. The big mistake students make is they write negligence and they write a big sweeping analysis of negligence. And where it is, where the points are, is that every element has a mini IRAC. You conclude issue, rule, application of the facts, conclusion, and you tie up that element. To whom is the duty owed? Same thing. Mini IRAC on these elements. Okay. Then, what has to happen is that you have to link this whole thing together. In other words, negligence doesn't require as much of a link as some other subjects, but each element and each analysis has to be linked so that at the end, the whole thing ties together. The last thing I want to say is under each of these elements, and this could be First Amendment, this could be easement, it could be contract formation. But the trick to this, the total trick to this, is that you make sure that you actually quote key facts. Under each of this mini IRAC, your element is your I, your rule is the rule that goes to that element, and in that application are the one or two key facts that determine that analysis. And under your application, if there's a plaintiff side, you should say it. Skip a line. If there's a defendant side, you should say that. Never weave it all back and forth. In other words, don't bounce around. Let's say we're on, whether A owed a special duty of care to B. You would say, head note special duty, you would write the rule. Here we have a common carrier who has a higher standard of care owed. Then what you would do is, if there is in your application, so it starts with your issue, your rule, and your application starts with the word here. Always start with the word here. Here, the plaintiff will argue that the common carrier owed a higher duty of care because it was a bus. However, skip a line, the defendant will argue that it was a private bus company and therefore not really considered a public common carrier. Therefore is how you start your conclusion. So the formula here is issue, rule, application starts with here. You argue the plaintiff side, if there is an argument. You argue, skip a line and argue the defendant side, if there is an argument. And then you have the head note or the therefore, and that's your conclusion. And you do this quickly, and you do this repeatedly, so that you get really good at this, that you get good at doing it quick and fast. You want to have it laid out for them, you want to make it fast for them, and you want to make it easy for them. Right? Because if you are grading, the bar examiners are grading about 35 to 50 exams a night. They're grading sometimes 35 exams a night. They're grading 150 to 200 exams a week. If you're grading 35 to 50 exams and you're getting paid $2.75 an exam, do you really want to pour over it? Do you really want to make them work? So someone asked a very important question that I want to address. The very important question that I want to address is, he asked whether you leave space in between sub-issues as well. And the answer to that is yes. So let's say we're in negligence, we've laid out the elements. We head note and leave space for duty. I do another line for the rule. I skip another line for application. Plaintiff will argue, skip a line, defendant will argue, reach a conclusion, therefore. So it's issue, rule, here, plaintiff will argue, here, defendant will argue, therefore. I have just given you the magic keys to the kingdom. Because when I went to law school, everyone told me how to everyone said IRAC. I never knew what it meant. I never knew how to do it. Okay, are there any questions on IRAC? Any questions on IRACing? Okay, now, what I'd like to go over right now is I'd like to do a torts approach for you. I want to highlight for you what's heavily tested, what I expect to maybe be on the bar exam coming up. And then what I'm going to do is I'm going to go over a torts question and show you in reality how to do what we just talked about. So, this segment of the course right now is going to be a torts approach we're going to go over together. So everyone open your approach book and open it to torts. What I'd like you all to do is always bring a highlighter. Always bring a highlighter, because I'm going to highlight for you what's important and what's tested. Now, everybody turn to your torts approach, and let's start torts page 3. So, actually let's start torts page 4. Highlight battery. I'm on the bottom of 4. Highlight battery. Highlight intent. Highlight harmful or offensive contact. Highlight causation. Highlight proximate cause. Highlight damages, and highlight defenses. Am I going too fast? Yes. All right, let me start that again. The reason that I went fast for battery is because battery is generally tested on the essays, and it's worth between 2 and 5 points. It's a minor issue. Occasionally on the California bar, they'll give you a major issue for battery, but it's very rare. So battery and the intentional torts are 2 to 5 pointers. So let's say something is worth 2 to 5 points. Would you do this full blown out IRAC? Would you head note battery? Would you have intent under battery and IRAC intent, and then have harmful or offensive contact and IRAC that on something that's worth 2 to 5 points? You would not. So one of the tricks of doing better on the California bar is being able to distinguish between major and minor issues. And how you determine if something is a major or minor issue. How do you determine if something's major or minor? Anybody? Yes. How do you determine if something's major or minor? Number one, how many facts are on it about it? If there's a lot of facts, it's a major issue. If there's minimal facts, it's a minor issue. The second way you determine if something's a major or minor issue is how many of the elements have any problem or any dispute. If they give you something and it's a battery and they tell you that A took this remote control, took this battery and threw it at B and it hit B in the face, and B's face was scratched and B was bleeding, that's not going to be worth 10 or 15 points. It's a get in, get out. This bar, and forgive me for saying this, is like a one-night stand. It's not a love affair. I know that Josh said you have to be in love with the bar, and it's true. You have to like this process. You have to enjoy it and not fight it, go with it, dance with it. But honestly, these essay questions and these issues are get in and get out. This is not romancing the stone. So it's key for you to pass to know major versus minor. Battery tends to be a minor issue. And when they test battery, they want you to define intent, harmful or offensive touching, quick discussion of causation, quick discussion of proximate cause, damages and defenses, get in, get out. You would not separately head note all of those elements. You would say, battery requires the intentional, harmful or offensive touching of another without consent or privilege, causing damages. And then you would say, here, intent is whether there was a volitional act. Here, A threw the battery at B, that shows intent. There was a harmful or offensive touching because it hit B in the face and scratched him. B was embarrassed and hurt. It caused B, it was the actual cause of B's injury. It was the proximate cause of B's injuries as nothing intervened. B was damaged, and there are no available defenses. Done. Boom, boom, boom. Okay? Battery is moderately tested on the California bar. Assault on the essays is almost never tested. I'm on false imprisonment, which is on, let me get glasses here. I'm on false imprisonment on page 6. False imprisonment is actually heavily tested. False imprisonment, highlight intent, highlight actually confines plaintiff within a bounded area, highlight overcoming plaintiff's will to leave, highlight causation, highlight damages, highlight defenses. Another quickie tort, intentional tort, is intentional infliction of emotional distress, heavily tested. We call it IIED, highlight intent, highlight extreme and outrageous act, highlight causation, and highlight severe emotional distress. Again, this one's worth 2 to 5 points usually. Don't spend a lot of time on these. Intentional torts to property, trespass, rarely tested. I'm on 7. Trespass to chattel on 8 is tested. Anytime you have a trespass to chattel, it goes with a sister issue of conversion. Is the trespass to chattel such an exercise of dominion and control that it amounts to a conversion? So you would lay out the elements for trespass to chattel, you'd lay out intentional act, interference with plaintiff's possessory right, causation, damages, defenses, and then your next head note would be conversion, and you'd say to the bar examiners that if this trespass to channel was such an exercise of dominion and control that it deprived the rightful owner of the property, then it amounts to a conversion. You don't need to lay out all the elements for conversion, but those torts go together. These torts are 5-pointers. We haven't gotten to any mega torts yet. Now, intentional interference with business relationships. These are the gateway torts to remedies crossover questions. We're going to discuss remedies crossovers at a different class, but the reason these torts are so heavily tested and so important is interference with contracts. Interference with contract, in an existing valid contract, defendant knowingly interferes, defendant intended to deprive or disrupt the contractual relationship, and plaintiff is damaged. The reason this is a gateway tort to a remedies crossover is because under this tort of interference with contract, some bar questions have a full contracts question underneath this tort because the first element is an existing valid contract. Almost all contracts remedies questions have one of these gateway torts in it. And that's where you get a torts, contracts, remedies cross. Or a torts remedies cross. Okay? So, you either have interference with contracts or you have interference with prospective economic advantage on page 10 of the approach. Anytime you have an interference with contract, you probably also have an interference with prospective economic advantage. These torts go together also. Another gateway tort is misrepresentation. Misrepresentation is a gateway tort between a torts remedies crossover, because if someone's misrepresented something, you might want to get injunctive relief to stop them from proceeding. Misrepresentation crosses over with wills. It can cross over in real property. It can cross over in community property. It can cross over in professional responsibility. For example, in professional responsibility, if an attorney misrepresents something to a client. So misrepresentation is one of those torts that you might see pop up in wills, community property, professional responsibility. So in a torts, sometimes the call of the question will say, what theory or theories? When a question says what theory or theories, theories means other subjects. So if it says what theory or theories, it's generally saying, is there a will? Is there a tort? Is there a problem in real property? I'm going to show you next time we get together about how to read the calls of the question, but I just want you to know for tonight that misrepresentation is a very important tort because it pops up in a lot of places. Okay. For misrepresentation, you need an intentional misrepresentation of a material fact. You need scienter. You need intent to induce plaintiff's reliance. You need plaintiff actually and justifiably relied. You need causing plaintiff damages. For negligent misrepresentation, you need misrepresentation made by the defendant in a business or professional capacity. Defendant breached a duty to that particular plaintiff. Plaintiff justifiably relied, and it caused damages. Okay. Malicious prosecution. The bar either doesn't test it for 5 years, or it's worth 50% of the points on a torts question. Abusive process and malicious prosecution will show up maybe every 4th to 5th bar, but when it shows up, it's a big bang. So you have to know it. And malicious prosecution requires malice, lack of probable cause, favorable termination of the underlying action, and damages. Abusive process, you have to have a claim was brought to further an improper purpose or a purpose other than seeking justice. 2, sufficient act or threat was used to accomplish that purpose. And 3, there's damages. It seems like there's almost nothing here. And then you'll look at some of the questions we give you. And the last call will be abusive process and malicious prosecution, and it's 30 points. So take those 30 points and run with them. Now, defenses. Over on page 11. Not really tested much on the essays. Not tested much at all. They are tested on the multi-state, but what is the difference between studying this material that includes the multi-state and studying this material if you're not taking the multi-state? If you are taking the multi-state, you need to study this in more detail. If you're not taking the multi-state because you're taking the attorney's exam, you don't need to study it in the same detail. Are you taking the multi-state? No, right, that's why I'm bringing this up. So you really, as an attorney, would just kind of read through the defenses to the intentional torts, because you understand you're not taking the multi-state. You don't need this kind of detail. That's nice for you, a certain way. Okay, so I'm not going to really have you highlight these defenses. Go through them, read them. You need to read them to be able to recognize them, but you're going to learn self-defense, defense of others through taking practice multi-state questions. You don't really need to memorize it. If you're not taking an essay on it, you don't need to memorize it. You need to simply recognize. Okay? Anyone else here not taking the multi-state? Okay. Now, everybody turn to defamation, page 14. This is a heavy hitter. This is heavily tested. And I expect this on your bar. I think they're getting ready to do a defamation con law crossover. And don't be making faces and don't be looking like that's a terrible thing. It's a wonderful thing. You're going to have spent so much time on defamation in here that you're going to welcome it. You're going to be like, yay, bring it. Because defamation, head note, print, underline, type, defamation. Defamation requires a defamatory statement of and concerning the plaintiff, publication, damages, and defenses. You better pray for defamation. Why? You can do it in your sleep. It's a formula. Some of the courses that some of you have taken before, their torts outlines are 140 pages long. Most of you in here know that that didn't work out so well. First-time takers, you're blessed with not having to go through that torture first, because when they test defamation on an essay, this is what they want. And this is the same thing they want every single time they test it. So, what do they want? They want head note defamatory statement after defamation. A defamatory statement is one which tends to lower plaintiff's reputation in a significant minority of the community. Formula, memorize that. Now we're going to apply it to the particular facts they're giving us here. When Joe said that Jill came to work with alcohol on her breath, this would lower Jill's reputation in a substantial minority of her community, as she is a kindergarten public school teacher. Other teachers, other administrators may not want to work with a teacher that comes to work with alcohol in her breath. Therefore, this statement is defamatory. Quote facts. Next heading, of and concerning plaintiff. Notice I skipped inducement and innuendo. I skipped inducement and innuendo because you need to know what it is, but you don't need to memorize it. Okay? Of and concerning plaintiff, head note, of and concerning plaintiff. Plaintiff must prove that the defamatory statement referred to her. Head note, publication of third persons. This must be published to third persons and understood to be defamatory. Formula. Next, damages. Highlight damages depend upon whether it's libel versus slander. Now, when I went to law school during the Civil War, the first thing that they said to us in torts, when we got to defamation, the first question the professor said is this libel or is this slander? Why does the BarWinners approach book have libel versus slander under damages? Why? Anybody know why? The answer is exactly what you said. The damage amount is the only thing that's affected as to whether it's libel or slander. Whether it's a defamatory statement, doesn't matter if it's spoken or written. Whether it's been published, doesn't matter if it's spoken or written. Whether it's referring to plaintiff, doesn't matter if it's spoken or written. The only place it matters as to whether it's libel or slander is proving damages. Because if it's libel, general damages are presumed. If it's slander, like we have here on the book, general damages are not presumed unless it falls within a slander per se category. And if it falls within a slander per se category, then general damages are presumed. Slander per se categories are lack of chastity of a woman, loathsome disease, accusation of a crime involving moral turpitude, or affecting plaintiff's trade or affecting plaintiff's trade or business. If it's one of those, even if it's spoken, general damages are presumed. The next heading is libel defendants. Who are your defendants? Are they libel? The last heading is defenses. And the only defense that they really test is a qualified privilege. And the qualified privilege is a limited privilege. And for example, if I am your employer, I have a qualified privilege to do a job recommendation for you. I can send a recommendation or a job referral indicating your skills or your lack of skills. However, I lose that privilege if what I'm doing is, on page 17, publication was not made in good faith. Publication was for vindictive purposes. Publication was beyond that necessary to achieve a proper purpose, or publication was made with malice. So the way the bar examiners test this is they test qualified privilege, an employer, and whether you get a loss of qualified privilege. Okay, now, the last issue we're looking at are constitutional privileges. And this is where I think you're going to get the con law crossover possibly. Because I'm on page 18, head note, constitutional privileges. Highlight it. In order to determine whether a constitutional privilege applies, you have to have a media defendant. The defendant must be media. It could be a law school newspaper, it could be NPR, it could be NBC, CBS, Fox, New York Times, LA Times. The media is the defendant. And the reason you get a constitutional privilege is that they want the media to be able to have freedom of speech. So the question is, it's not an unlimited freedom of speech. In other words, you don't have an unlimited right to defame somebody. So the question is, here on page 18, is number one, we always know the media is the defendant. Is the plaintiff a public figure or public official? If the plaintiff is a public figure or public official, the media has a stronger constitutional privilege. Because if you put yourself in the public eye, if you're a celebrity, if you're an elected official, then the only way, the test for whether the statement is defamatory is under New York Times v. Sullivan. If the plaintiff, you have to show malice. If the plaintiff is a public figure or public official, you have to show the defendant is liable if there was actual malice. Actual malice is reckless disregard for the truth. It's a subjective test. You have to show there was actual malice. Excuse me. If the plaintiff can show actual malice, they can recover. If they're a public figure or public official. If you can't show actual malice, you don't recover. Now, what happens if the plaintiff is a purely private person? On page 19. Private person versus the news media. It's a non-public person. The test is Gertz v. Welch. The first thing you look at is whether this is an issue of public concern or a private matter. Are they talking about a private person who sexually molested some children, which is a public concern? Or are they talking about a private person who had an affair, which is a private concern? If the subject matter is of public concern, the plaintiff needs to show negligence in order to recover. And negligence is determined by, would a reasonably prudent editor or publisher know or should have known that the statement was defamatory? This is an objective standard. And the damages, plaintiff must show actual injury. If the matter is purely a private matter, it's purely a private matter, whether you're a private person and you had an affair with your neighbor, if it's a purely private matter, then common law defamation rules apply, and the media loses their constitutional privilege completely. If it's a purely private matter, the media loses their defense of constitutional privilege. Okay, now, invasion of privacy. 4 types of invasion of privacy. I'm on page 20. Misappropriation of name or likeness for commercial purpose. The Jackie Onassis plaintiff's right to be left alone. That was the photographer going over the fence for Jackie O and taking nude pictures of her. Okay? False light publication and public disclosure of private facts. Now, obviously those invasion of privacy is not as heavily tested as defamation. It can be. There are constitutional privileges to invasion of privacy. The constitutional privilege under invasion of privacy is Times v. Hill on page 22. The media is privileged, absent malice, but they have to establish, the plaintiff has to establish falsity, and the plaintiff has to establish actual malice. Malice is reckless disregard of whether it was true or false. Okay. The next most heavily tested subject on the torts area of the bar is negligence. I believe the July bar had a negligence question, but I could be wrong. Negligence is heavily tested. Highlight my definition of right on the bar. In order for the plaintiff to recover a negligence, she must plead and prove duty, breach of duty, actual cause, proximate cause, and damages. Your first heading, highlight, is duty. Under duty, highlight a general duty, and I'm going to give you a break soon, so not to worry. On every negligence question on the California bar, you must write general duty, because everyone has a general duty to act as a reasonable person would in like or similar circumstances to avoid unreasonable risk of harm to others. Your next heading is special duty, and you're going to check this for special duties. And the most heavily tested special duties are professionals, guests and common carriers on page 24. Owners and occupiers of land, heavily tested. The most heavily tested in these two are licensees and invitees. Child trespassers is not tested as much as people think. Omissions to act are tested. Omissions to act is where somebody doesn't do something, and the law only opposes the duty to do something if there's a special relationship. Okay? I'm on page 27. Head note, to whom is the duty owed? And I'm giving you the template for how you're going to answer a negligence question. I've condensed it. I've put it together. I've given it to you in elements. I've done the work for you. You just need to follow what I'm giving you. Okay? That's why this outline is shorter and more to the point. To whom is the duty owed? You have to write under Paul's graph. Remember old Paul's graph, Mrs. Paul's graph standing on the railway station. Under Paul's graph, Cardosa said that a duty is owed only to foreseeable plaintiffs in the zone of danger. And Andrews said a duty is owed to everyone in the world. So on the bar, you say, if this jurisdiction follows Cardozo, a duty is only owed to foreseeable plaintiffs in the physical zone of danger. However, under Andrews, a duty is owed to everyone in the world. Okay? Breach of duty, head note, highlight. Breach of duty is basically taking the facts in the fact pattern and holding them up to the standard of care and determining what a reasonable person would do in like or similar circumstances to avoid unreasonable risk of harm. Actual cause, highlight. Two types of actual cause. If there's only one defendant, the test is but for. But for this defendant, the injury would not have occurred. If there's more than one defendant, whether each defendant was a substantial factor in bringing about the plaintiff's harm. If you have more than one defendant, it's substantial factor test. One defendant, it's the but-for test. Okay. Proximate cause. Proximate cause is where everybody screws up on the bar exam. Because a lot of you had Wagamount and Palimas and burning ships and all this nonsense. On proximate cause, the first head note issue is, was causation direct or indirect? Direct means nothing intervened between the plaintiff's act and the defendant's injury. Indirect means that something came in between. Okay, so head note number 1 under proximate cause is direct versus indirect. If causation is direct, there's no points. If causation's direct, there's no points. The only time points are addressed and the only time you're going to have a lot of points on the question is if causation's indirect. Causation is indirect when something intervenes. And the question is whether that intervening act is going to relieve the original defendant of liability. Okay. Head note number 1, indirect causation. Head note number 2, is causation, that intervening act, dependent or independent? Dependent means that cause, the intervening act, was dependent on the original defendant's bad act. Independent act is an act of God, act of children, act of animals. If your intervening act is dependent, your next head note is foreseeable or unforeseeable. So here's how proximate cause goes. Head note, proximate cause, direct or indirect. If causation's direct, you're in and out in 5 minutes. If causation is indirect, the next issue is dependent or independent is your next heading. After dependent and independent, your next heading after that is foreseeable or unforeseeable. I have just boiled down for you 3 months of torts class of proximate cause. This is all the bar examiners are looking for. Head note, direct versus indirect. If it's direct, then the defendant is the proximate cause of plaintiff's injury and is foreseeable. If it's indirect, the question head note, dependent, independent. If it's dependent, was it foreseeable or unforeseeable? If it's independent, was it foreseeable or unforeseeable? Formula. And when you apply this enough to questions, it's going to become very easy. Formula. Not a lot of thinking. How much time do you have on this bar to really think? And actually, they're grading you so fast, they're not thinking either. Right? 1 minute? They're looking for the formula. Give them the formula. I've given it to you. Memorize the formula. Practice applying it to questions. Look at the sample answers on those practice questions. Open your book and keep your book open and do questions. You want this to fit like a glove. You want this approach book to become part of you. You want it to be a love relationship. You want to embrace. Not fight, not struggle, but embrace. Because the things you embrace, you flow with, and they manifest. And the things you struggle with, you resist. Many of you who are repeat takers are struggling with this bar. And first-time takers, you're not struggling with a bar, but you're learning how to dance with them. You're learning how to follow. They're leading. What every bar examiner has said to me, I just want the student, the applicant, the attorney applicant, to answer what we've asked. They don't want an answer like a conclusion, like is A negligent? They don't want you to write yes, but they want, how do you feel when people don't listen to you? How do you feel when you say to your wife, honey, I really want a pepperoni pizza tonight? And she thinks, you know, I know he wants a pepperoni pizza tonight, but I'm going to get him a gluten-free tofu pizza. How happy are you when she walks in with the tofu jerky pizza? Very unhappy. Bar examiners are very unhappy when you don't answer what they've asked. They feel not listened to. All you have to do, even if you don't know the law, is respond to what they've asked. Are you going to know the law perfectly? Nah. Are you going to know the law spectacularly? No. Do people fail the bar because they don't know the law? No. That is not why people fail the bar. People fail the bar because they don't answer what the bar's been asking them. And they fail the bar because they want to talk about what they want to talk about and not what the bar has asked. Some of you are here for that reason. Some of you want to talk about what you know better. How many of us in law school took a law school exam and wrote about what we knew more information on and not what was asked? Did anyone do that? I did. I would write on stuff they didn't ask because some of what they asked I didn't know. And I thought I could fool them or get them off track by writing about something else. Do not do that. Yeah, do not, respond to what they've asked you. That's all they want. It's a marriage. It's a relationship. None of us want to be in relationships with unresponsive partners. Anybody in here want to be in a relationship with a partner that's not responsive? Does anybody like feeling not heard or understood? None of us like it. And the bar doesn't like it. So, just give them what they ask, even if you don't know it perfectly. There's no perfect. The scoring on this bar to pass is like a C minus. It's barely above a D. Minimal competency. People who pass the bar, are they the best lawyers in the world? How many of us have been in a courtroom and thought, oh dear God, how did this person ever pass the bar exam? Oh my God, you gotta be kidding me. Judges put their head in their hands and go, oh dear Lord. Okay? Doesn't mean if you've passed or haven't passed that you're gonna make a good lawyer or a bad lawyer. It isn't personal. They're not testing, are you gonna be a good lawyer? If they were testing, are you gonna be a good lawyer? It wouldn't be this exam. They're testing, are you minimally competent enough that we as a licensing agency feel we're protecting the public? You don't need to be right. You don't need to be perfect. You don't need to have the right answers. You just need to move with them and respond to the best that you can. You do need to learn the law as best as you can. So, let me get back to negligence. We just did proximate cause, direct versus indirect. We just did, if it's indirect, dependent or independent. If it's dependent, foreseeable or unforeseeable. If it's independent, foreseeable or unforeseeable. Boom, 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 home run. Is it a creative? Is it unique? Are you being phenomenal? No. All that creative, unique, phenomenal, save until you're practicing law and are a licensed attorney in California. Some of you are already licensed attorneys in a lot of places. Last thing you're going to talk about is damages. You have to prove that damages are certain, foreseeable, unavoidable, and non-speculative. And I'm on page 29. And defenses. Heavily tested are the defenses of contributory negligence and heavily tested assumption of the risk. Some jurisdictions in California are comparative negligence. Some are contributory negligence. Comparative negligence is those jurisdictions where they assign a degree of fault and the plaintiff's reward is reduced by their degree, the plaintiff's reward of their fault. Some jurisdictions, if the plaintiff was negligent at all, it's a complete bar. Okay? That's about as much time as I would take on comparative negligence. Sometimes people write pages. Why wouldn't I write pages? There's no points. Okay. We're almost through it. Another very, very, very heavily tested area, products liability. Products liability. I am giving you the formula for products liability. I have seen products liability screwed up in more substantive bar review outlines than you could possibly imagine. Follow this. Follow this. And what you're going to do under products liability is you're going to say there are 5 possible theories of recovery. I'm on page 30. You're going to head note only those applicable are going to be discussed. The first head note, strict products liability. You're going to head note proper plaintiff. You're going to head note proper defendant. You're going to head note is the product defective. And there has to be a defect in either design or manufacture. If there is a defect in design, there are 3 more sub-issues you have to head note. A, commercial expectation approach, consumer expectation approach. B, feasible alternative. And C, defect and lack of warning. So here's the formula. Products liability, there are 5 possible theories of recovery. They are strict liability, negligence, express warranty, implied warranty, misrepresentation. Head note 1, strict products liability. Head note, proper plaintiff. Here, A is a proper plaintiff because they were a foreseeable user of the product. They're a foreseeable user of the product because they are a household guest, and this is a common household product that people living there would be exposed to. Proper defendant. The bug spray company is the manufacturer of this product and therefore is a proper defendant. Is the product effective? We're not talking about fault here. Any bar review material that has under strict liability standard of care, don't use it. There's no negligence in strict products liability. That's the whole point of it. It's strict products liability. You don't have to prove fault. When I first got out of law school, I did airplane crashes. All of the clients were dead. They didn't give us any problems, but because people don't survive airplane crashes. And if we always wanted strict products liability because we never had to prove fault. We didn't have to prove someone was negligent. We only had to prove the product was defective. And we did the, DC crash out of O'Hara, and we did the, PSA crash in San Diego. And how did we prove the product was defective? Well, engines don't normally fall off unless there's a problem. Of course, the plaintiff was always trying to say pilot error. Right? Pilot error. That's the famous pilot error. But the truth is, strict products liability, proper plaintiff is your heading, proper defendant is your heading. Is the product effective? Either in manufacture, if there's a defect in design, 3-prong test under that. I've just given you the formula. Do you need to be a genius to do it? Do you need to be the most smartest person in the world? Any questions on the strict products liability formula? Then you're going to talk about actual cause, sentence or 2, highlight that. Proximate cause, sentence or 2, highlight that. Damages. Next head note, negligence, products liability. You must always discuss all the theories that apply. I cannot tell you how many bar exams I've looked at where somebody had strict products liability, never discussed negligent products liability, and never discussed warranty. You must discuss all that apply. Why? Because there's points. Because products liability can be worth 30 points. There's points for strict products liability, and each of those headings is an element, and each of that element gets IRAC'd. And there's points for negligent products liability. And negligent products liability, first head note is duty. Manufacturers and designers must act as reasonable manufacturers or designers would act in manufacturing or designing this product. You have to prove fault. You have to prove a breach of duty. You have to prove a duty was owed to this particular plaintiff. And you need to prove actual cause, proximate cause, damages, and defenses. Something I want to tell you about negligence products liability is do not confuse the reader that you think it's ordinary negligence. Negligent products liability has its own language. Okay? It cannot be discussed as ordinary negligence. It always has to have the products liability wording in it. Okay? Now, express warranty, I'm on page 34. For an express warranty in a bar exam question, they have to give you an express warranty. If they don't give you an express warranty, the issue does not apply. And the express warranty can't be something like, we promise this product isn't toxic. Express warranty has to be much more definitive. If they don't quote express warranty language, it's not in the question. Okay. Implied warranty. It's the number one issue in products liability that people miss 10 points. Because people will discuss strict liability, negligent products liability, and leave out implied warranty. It's a gimme 10 points. Implied warranty in the sale of every product, there is an implied warranty of merchantability and implied warranty of fitness for a particular purpose. And I'm on page 34. Highlight those. Privity used to be a big problem in implied warranty, but they've extended it to the buyer's family, household members, and guests injured by the product. So I am here to tell you, I doubt if the bar is going to give you a products liability question that doesn't involve strict products liability, negligence products liability, and implied warranty. That's the trio. That's the Three Stooges. There were Three Stooges, right? Okay. We're almost there. We're on page 35. Strict tort liability. Do not confuse this with products liability. I've had people on exams with a can of bug spray. A kid thought that the bug spray was perfume, and the kid sprayed himself with the perfume. And I've had more people say strict liability. Why does strict liability not apply to a can of bug spray? It is not an inherently dangerous activity. Thank you, that's right. Strict liability applies in two situations. It applies to animals. California, no free bites for dog bites. Your dog bites somebody, you're strictly liable. If he bites you, tough luck. Okay? Wild animals, strict liability. The one that's really tested on this bar is inherently dangerous activities. For inherently dangerous activities, I'm on page 35. Head note, highlight, activity poses serious risk of harm to personal property. Highlight, activity cannot be performed with complete safety. And highlight, activity is not conducted in this area usually. You need causation and damages. Assumption of the risk is a defense. Contributory negligence is not. Contributory negligence is not a defense to strict liability because strict liability says this happened without fault. There is no negligence. You're strictly liable. Wild animals and inherently dangerous activities. Okay? The last one I'm going to go over in torts tonight is nuisance. It's heavily tested. It's heavily tested because it's a gateway to remedies. Because if somebody's creating a nuisance, you want to enjoin that nuisance, you want to stop the nuisance. So they test nuisance fairly often, actually. And there's two types of nuisance. One is public nuisance. For public nuisance, the head notes are, subheadings are substantial interference, unreasonable interference. You balance unreasonable interference, weighing the risk of harm as opposed to the benefit of the activity. This is heavy in fact analysis on page 37. And in order to recover for a public nuisance, the plaintiff must suffer a special injury. They must suffer a unique injury. And then anytime you have a public nuisance, you must discuss private nuisance as well. Okay? Private nuisance is substantial unreasonable interference with plaintiff's use and enjoyment of her land. Last but not least is vicarious liability. Vicarious liability is very heavily tested on the California bar. And vicarious liability is always tested in situations where the fact pattern asks you about the employer as the defendant, but only gives you what the employee did. So what you're going to have to do if the call says, Plaintiff wants to sue the bus company for negligence. But all the fact pattern gives you is what the driver did. In order to get the defendant that's asked for in the call, you have to find whether the employee that they give you facts about was acting in the course and scope of the employment, so that if the employee was negligent and acting in the course and scope of employment, it gets imputed to the employer. Okay. We just did a whole year of torts. At least a semester in some law schools. Are there any questions before we take a break? So what we're going to go through is I'm going to show you how to outline and write an actual bar exam question. So for this class, will you go to Torts question Peter's wallet in your question book? Everyone turn to Peter's wallet. And this question can be found, both the question and the answer can be found in the BarWinners question and answer book in the Torts section. Peter's wallet. If you want the BarWinners cut sheet of this particular question, you can log into Moodle and get it. All right. So let me open my own question and answer book. And we're going to do this, all of us are going to do this together. So let's start reading together, and let's go to the call of the question first. What does the call of the question say first? Everybody take out a sheet of paper, and everybody hold that sheet of paper this way. Because what we're going to do right now is I'm going to show you how to outline a bar exam question in 15 minutes. This is the key to passing the essays for the California Bar. So, what did we talk about before? We talked about having this structured exactly like the call of the question. So the first call of the question, read it to me. What is number A? A says what? What are Peter's rights against one, and who's number one? Peter versus Jim. We're going to put a line just like that, okay? What's number two? What about David? So it's Peter against David, okay? And what's number three? Peter versus Busco. And what is B? David versus Peter. Okay, so every single one of you should have this written down on your paper with the columns. And it should be numbered A, what are Peter's rights against? 1, Peter versus Jim, make your column. 2, Peter versus David, make your column. 3, Peter versus Busco, make your column. And B, David versus Peter. And you're going to see when we go through this question how these columns are going to save you. And I'm going to come around for a second and check and see if you're doing this the way I'm asking you to. Kind of messy. Not in pencil, give it to me in pen. Peter versus Jim. Peter versus David. Peter versus Busco. Okay, but notice what's missing. Can I just use this as an example? Okay, I just looked at a student's layout of this question, Peter's wallet. And he has A, 1, Peter versus Jim, 2, Peter versus David, but then he has Peter versus Busco with no number 3. Remember I said you have to number exactly like the bar? Because your grader could go get a drink of water and come back and go, wait a minute, what number am I on? And the last column, you have David versus Peter with no B. So this is the beginning of passing the bar. And it's so easy to leave stuff out. And thank you for letting me demonstrate looking at this, because a lot of people make this mistake. And for attorney applicants, this is almost one of the hardest things they have to do, is actually number and letter just like the bar. Okay, let's read this together, and I'm going to hand this back to you. Thank you. Let's read this together. Okay, the question starts out, I'm going to have you start reading here, Bob. You start reading? Yeah, and read slow. Okay, Peter carelessly left his wallet. Any issues there? What? Here, the fact pattern tells you carelessly. Who is Peter? He's the plaintiff. What is it when the plaintiff is careless? It's contributory negligence. But what we know is that you can't write a defense of contributory negligence before you lay out the prima facie case of negligence first. So what I would do with this is on the very bottom of my column, I would put defense, contributory negligence, and I would quote P, careless. I would do that in the beginning because I don't want to forget this defense. The first paragraph says Peter carelessly. Peter is the plaintiff. When the plaintiff is careless, it's going to make me think of a defense of contributory negligence. I don't know if I'm right, but I sure want to put it down while I see it. Okay? Let's keep reading. Okay, and somebody give me your wallet. Don't all reach for your wallet, just give me your wallet. Anybody have a wallet? Throw me your wallet. Oh, you guys are terrible. You don't carry a wallet? That's a good solution. It's an embarrassment? Uh-oh. I love this wallet. So funny. Is this really your wallet? Oh my God. It's fantastic. Okay, so Peter walks into, who owns the restaurant? Jim. And Jim is our defendant here. It's his restaurant. So what happens? Peter walks into the restaurant, pays his tab, leaves his wallet, walks away. What does Jim do? Jim does nothing. So and then what happened? Jim does nothing. Peter doesn't get his wallet. What happens in between? David comes in and picks up the wallet. So, if Peter is suing Jim, what's the issue? What do you think the issue might be? Good, negligence. So what you're going to do on your outline is you're going to put negligence. This is your 15-minute outline. And under negligence, you're going to have duty, general duty, and special duty. Leave more space than I'm leaving on the board. Leave more space so you can fill it in. Negligence, duty, general duty, special duty. To whom is the duty owed? Maybe. Hold on. We're going to have breach of duty. We're going to have actual cause, proximate cause, and defenses and damages. Do you remember I told you in the beginning of the class that once you saw an issue, I gave you the template and the formula? And of course, it's easy to see in torts and negligence, but it's also easy to see in every subject. I'm using torts to explain the methodology of how this whole thing works. So, Peter versus Jim, the first head note is negligence. The first issue is duty. Everyone owes a general duty to act as a reasonable person would in like or similar circumstances. Are there any special duties here? You must checklist for special duties. Any special duty? Maybe. But we have a fundamental problem here. We have a fundamental problem here. You're right, he's an innkeeper. Right. Here's the problem. Peter goes to pay his bill, leaves the wallet. Jim doesn't do anything wrong. What's the problem? Jim, what? Jim, what? Neglected. He omitted to act. An omission to act is a special duty. And under this omission to act, most of the time in the law, you're not required to do something. You don't get punished for not doing something. When do you get punished or found guilty or sued for failing to do something? Is that right? Is that right? One person said when a reasonable person fails to act, another person said when there's damages. Jim's issue was that he didn't do anything. In the law, do you have to do something? You don't have to do something. You can see a car accident and drive right by. You could see a wallet and do nothing unless there's a special relationship where an omission to act with a special relationship imposes upon the party a duty to act. And what is the special relationship here? You said it already. He's a restaurateur. He's a restaurateur. He's like an innkeeper. So, we have an omission to act, special duty, with a duty to act. He has his premises open to the public. He's like an innkeeper. Also, bailor, bailee. So, Jim does nothing, right? It's almost as if Peter entrusted Jim with his wallet. Jim, what should Jim have done? He should have said, hey, Peter, you left your wallet. Or, what would a reasonable restaurateur do? Put it away for safekeeping. Put it in a drawer. Put it in the security cabinet. This Jim does nothing. So, duty, general duty, special duty, omission to act. Omission to act is not in and of itself a problem unless there's a special relationship or a special bailee, bailor. Here, there's a special relationship. He's an innkeeper. He holds his premises out to the public. There's no issue of to whom was the duty owed. Is there? Because he's in his foreseeable zone of physical danger. Was that duty breached? Did Jim breach his duty to Peter? Give me the facts. Tell me why. Okay, very nice. I would do it shorter, but you have the right idea. The right idea is to say breach of duty. Here, a reasonable restaurateur or bailor would have either called the wallet to the patron's attention or put the wallet away for safekeeping. Jim breached his duty to Peter. Now the question is whether Jim was the actual cause of Peter's harm. Can we say that but for Jim, Peter would not have been injured? Can we say that? Maybe. What about David? I think we have to say here, for actual cause, that in some jurisdictions, Jim would be considered the but-for cause of Peter's injury, because but for Jim not calling the wallet to Peter's attention, David picked it up. However, in other jurisdictions, it may be looked at that both Jim and David were substantial factors in bringing about Peter's harm, and each will be held responsible. Okay. Proximate cause. Did anything intervene between Jim not calling the wallet to Peter's attention and Peter's injury? Did anything intervene? David. David intervened. David, the wallet's sitting on the counter. Jim's zoning out to what is the sound of one hand clapping. He's spacing out, doesn't protect the wallet, doesn't call it to his attention. David walks in. Question is causation direct or indirect? And I need to leave more room here, hold on. Under proximate cause, my heading would be direct versus indirect. Causation here is indirect because there's an intervening act. My next heading would be dependent versus independent. And then my next heading is going to be foreseeable versus unforeseeable. Right? So, we know the causation's indirect because there was the intervening act of David. Was David's intervening act dependent on Jim's original bad act or independent act of God, a crime? It was dependent. David would have never picked up the wallet if Jim had called it to Peter's attention. So it is dependent. Is it foreseeable that if a restaurateur fails to safekeep someone's personal property, that that plaintiff would be injured? Yes. We just knocked out proximate cause. Boom, boom, boom. Had no direct, indirect. Had no dependent, independent. Had no foreseeable, unforeseeable. Now, you may wonder why I'm banging on this so hard tonight, because proximate cause is where everybody gets into trouble on this bar. Okay. Our next heading then is, are there any defenses? Right? Are there any defenses? And sorry for this being so low on this board. Any defenses? Didn't we already talk about contributory negligence and the fact that the plaintiff was careless and left his wallet? So the rule is that the plaintiff has to use that degree of care of a reasonably prudent person would in preventing harm to themselves. He breached that duty to himself. Probably Peter was contributorily negligent, and the damages are the loss of the $100 wallet. Let's keep reading, okay? Let's keep reading. What happens as David was leaving the restaurant? Oh, we have another issue here. Wait a minute. He picks up Peter's wallet thinking it's his own. David picks this wallet up saying, hey, this sure looks like mine. What's the issue? And under which column? Peter is going to sue David for picking up the wallet and thinking it was his own for trespass to chattel and conversion. Why conversion? And the facts tell us, what did David do with the wallet? The facts tell us that David, he picked up Peter's wallet thinking it was his own. David takes this wallet, boards a bus. The wallet gets thrown, I think, out the window. Okay? So we've got a pretty substantial exercise of dominion and control. When he first sees the wallet and picks it up, that's the trespass to chattel. When he now is la-di-da, boarding buses, throwing the wallet around, it's a conversion. These aren't worth as many points as this, but you have to have it. Okay, keep reading. Next sentence. As David was leaving the restaurant, what happened? Right. And then what happened? David boarded a bus owned by Busco. Why are they telling you he boarded a bus owned by somebody else? And under what call are we on? We're on Peter versus Busco. David boards a bus owned by Busco. Our first issue is going to have to be respondeat superior. Because under respondeat superior, the call of the question asks us about Busco, but the fact pattern tells us about the driver. And when they say he boarded a bus owned by Busco, you better start thinking respondeat superior. Let's keep reading. Okay? Almost. So Peter does what? And what happens? He boards the bus just as it starts to move, and Peter skins his knee. Now, if this were New York or Chicago, this would not be on a bar exam. But because it's in California and nobody rides a bus, somebody getting on a bus and the bus moves and they skin their knee is a big deal in California because nobody takes the bus anyway. Seriously, in New York, this would not be a bar question. It would be considered too ridiculous to even consider. If a subway was moving and someone boarded it, it wouldn't be a question. Okay, so Peter is boarding the bus and the bus driver starts to move as he boards the bus. What's the issue? What call are we on? Peter versus Busco. What's the issue, Bob? The issue is negligence. Good. Now, don't let me forget to give you this wallet back. Negligence. Even though we have negligence laid out over here, we need to lay it out again. No infra, no supra, no screw off. I already wrote this before. You have to lay out duty, breach of duty, actual cause, proximate cause, and damages. Do you need to do full, huge definitions? No. But you still need all of these head notes. Yeah. I left out to whom is the duty owed. Thank you. And don't do what I did. Make sure you leave more room on your paper. That's why you leave lots of space. And sometimes when you're doing a 15-minute outline like this, you'll use 2 sheets of paper. It's okay to have your outline on 2 sheets of paper as long as one sheet is here and the other sheet is here and the columns go down. Does that make sense? So the column would go down here, column would go down here. So I would use 2 sheets of paper. Yes? No. The question is, for respondeat superior, would I put it in breach of duty? Respondeat superior either gets put first in an analysis or last. And I put it first so I don't forget it, but I point out to the bar examiner, the fact pattern asks about the defendant Busco in the call. The fact itself mentions the activities of the driver. In order to make the driver's actions imputable to the employer bus company, we must determine whether there's respondeat superior. Because this defendant's being asked about, but I don't see Busco anywhere in this fact pattern. I only see the driver. And if the driver is not acting within the course and scope of their employment, Busco's not responsible. Let's say that this particular driver decides he's going to impress his girlfriend and pick her up in the company bus, and he's off duty. Busco would not be responsible, but here, he's in the course and scope of his employment, he's driving a bus, this guy's boarding the bus. So, respondeat superior, you say that if the driver's negligent, it will be imputed to the employer Busco if it's in the course and scope of the employment. Here, it's a bus driver driving for Busco, it's in the course and scope of employment. Therefore, we must look to see whether the driver was negligent. And again, attorneys that take this bar exam do not think like this. They do not think like this. They don't think about these point-getting factors. They don't think they have to relay out the elements if they've already laid them out over here. This is not related to this, is not related to this, is not related to this. These all have separate points. 25, 25, 25, 25. Pretty much. So, was there a duty? General duty, reasonable person. Any special duty? Common carrier. It's a bus company. There's a special duty when you're a common carrier to when you hold things out for the safety of the public, to act even more carefully. To whom is the duty owed? There's really no issue of to whom is the duty owed because Peter is in the bus company zone of danger. He's boarding the bus. He's not Mrs. Palsgraf standing on some train station too far away when the bomb goes off. Yes, the special duty is owed to those people who make use of the common carrier. Peter was boarding the common carrier bus, and therefore special duty applies. Breach of duty, a reasonable bus driver would have stopped when the patron was boarding the bus, and here the driver was breached their duty because he did not stop and allow the passenger to board before he pulled away. Actual cause, any intervening act, but for bus driver pulling away, Peter would not have skinned his knee. Proximate cause, nothing intervened. Causation's direct, it's foreseeable that if a bus driver pulls away with passengers loading, someone could get hurt. Any defenses? I mean, I don't think it's contributory negligent. You're boarding a bus, the driver's supposed to stop, and I don't think you assume the risk. But if you had it and you wrote that, you wouldn't have gotten counted off. Okay, there's an argument that a student just indicated that says that Peter followed and managed to board the bus just as it started to move, almost indicating that he started to board the bus as it was actually moving. You could argue that. Contributory negligent, maybe. Or the bus shouldn't have moved while a passenger was boarding. Either way is fine. He was damaged, skinned his knee, and therefore Peter can sue Busco for that. Now, what happened next? The loud accusation angered David, who even after he noticed that the wallet was not his own, said, "Don't call me." Oh, we skipped something. Wait a second. Let's back up. I'm in the second paragraph. He skins his knee. Peter then works his way around to David and says, "Stop, thief," to where David stood. So Peter works his way to David and says, "Stop, thief." What call are we on? Peter works his way around to David and says, "Stop, thief." What's the issue? Defamation. Good. How hard would this question be if you don't have these templates memorized? Ridiculously hard. Secondly, without these columns, your exam answer is going to look like a hellish nightmare. Because this question, the fact pattern, jumps from this column, here, here. So, under defamation, defamatory statement of and concerning plaintiff, publication, damages. Under damages, I always do libel versus slander. Defenses. Okay, now, was this a defamatory statement? A defamatory statement is one which tends to lower plaintiff's reputation of substantial minority of the community. Peter stands in front of David and says, "Stop thief." This would lower David's reputation in the minority of the community of bus patrons calling someone a thief. Was it of and concerning David? The facts tell you that he worked his way around and stood in front of him. So the sub-issue here, I think, is colloquium, that people around would understand that this was of and concerning, David because Peter stood right in front of him. Okay? It was published because there were other passengers around who heard it and would understand that he was being accused, David was being accused of being a thief and stealing the wallet. And was this libel or slander? Stop thief. It is slander because it was oral. So it's slander. What is the problem with slander? General damages are not presumed unless it is slander per se. Slander per se, are any of our slander per se categories applicable here? It's slander, slander per se. And the slander per se category that's applicable here is crime involving moral turpitude. He called him a thief. Therefore, David can recover general damages and special damages if he can prove them. Any defenses? Any defenses? Does Peter have any defenses? But the guy thought the wallet was his own. One of the students said truth, but he didn't intend to steal the wallet. He picked this wallet up because he thought it was his own. And mistake is not a defense. Yes? Right. No. The question is, because we have a trespass to chattel here, it was mistaken. David thought the wallet was his own. He didn't intend to steal it. But for an intentional tort, you only need to intend to do the act. You don't need to intend to do the consequences. So I think this is my own, but it's a mistake, doesn't matter. I volitionally took the wallet. Here, there are no defenses of this for truth because he wasn't a thief. His intent wasn't to steal it. His intent was that he thought the wallet was his own. Okay? All right, and what happens last? What happens? So David gets mad, and David says to Peter, "Don't you call me a thief. Take your friggin' wallet and get out of here." And he throws it at him. And the wallet hits Peter in the face and flies off. What is that? That's a battery. Under which column? David, who throws the wallet? David throws the wallet, so it's going to be under Peter versus David. We have a battery. I'm here to tell you this question people failed in California because they got all the parties mixed up and they didn't put the right torts in the right columns. Okay? So, David takes the wallet. David throws it, it hits Peter in the face. Peter sues David for battery. Battery is the intentional, harmful, or offensive touching of another without consent or privilege. It was intentional, he threw it. It was harmful or offensive, it hit him and glanced off his face. And it caused him damages. We have a battery. What else happens here? Not that we need anything else. Where? Peter tries to get off the bus, but they won't let him off the bus because he hasn't paid. So the issue is false imprisonment, and it's under which call of the question? Peter versus Busco. So under Peter versus Busco is false imprisonment. And false imprisonment is the intent to confine to a bounded area. Here, the bus driver confined him to a bounded area because he wouldn't let him off the bus until he paid the bus fare. Are there any defenses to this false imprisonment? Shopkeeper's immunity. A shopkeeper has the right to detain someone temporarily if they haven't paid for an item in the store or there's a suspicion. Now, thank you, sir, for your wallet. I'm going to throw it back to you. Good catch. Okay, now do you understand that we can now write this question without this 15-minute outline? Can you imagine the mess this is going to be? Because what would happen without the columns is that after something occurs to you that you read and you start writing about it, then it's an analytical mess. So the first 15 minutes is critical. And what I would do if this was my 15-minute outline is that I would put quotes of key facts next to these. I would quote 1 or 2 words. I didn't do it here because this is already hard to read in a mess, but I would quote key facts. Battery, through wallet, hit face, trespass to chattel, picked up, thought it was his own, conversion, boarded the bus, threw it out the window. I would put the key facts. So, you have 2 homework assignments from tonight's class. Homework assignment number 1 is the hardest homework assignment I'm going to give you in this class. It's the hardest assignment I'm going to give you. I warn you. I want you to make a study schedule that schedules out from now until 10 days before the bar exam. And your study schedule can be done on a big blank calendar, and you take a picture of it and you upload it to Moodle. Or it can be done on the schedule that we have on Moodle that you can fill out, or a schedule for a computer like on Microsoft Office. But what I want you to do is I want you to tell me and yourself, I want you to take each subject, all 14 bar subjects. I want you to open your approach book. I want you to go to the overall approach in each subject. So let's say everybody open your approach book to contracts. Open your approach book to contracts and open contracts. Page 1. And you can see in contracts that contracts is broken down into 6 major areas. I want you to schedule for your study schedule every subject broken down by the areas in the approach where it says approach overview. In every subject, the first page says, after the table of contents, says approach overview. Contracts has 6 areas. Real property has 8. Evidence might have 7. And you need to schedule for each area when you are going to outline it if you're outlining. If you're not outlining, when you're going to highlight and memorize. How many MBEs you're going to do that day in that area. And you need to schedule when you're going to do application, which is either your study group questions, home study questions, or your in-class questions. You're going to leave the last 10 days before the bar blank. You're going to tell me on this study schedule when you're taking breaks, when you're going to the gym, when you're spending family time, when you're going out on a date with your wife or girlfriend, or your wife and your girlfriend. Hopefully not. This is going to take you a long time to make. I want it done by Thursday night's class, but honestly, you can upload it to Moodle by Saturday. Upload to Moodle Saturday. Your calendar. And this calendar needs to be specific. I need to see, you need to see, that from 8 to 8:30 in the morning, you get up and you exercise. From 8:30 to 10:30, you do 15 multistates and make your flashcards in negligence. From 10:30 until 12:30, you do intentional torts. 12:30 to 1:30 lunch. 1:30 to 3:30, negligence. You need this calendar. I get the most fights about. I get the most tantrums. I get the most I can't do it. I get the most bitching and moaning. And I get the most people that don't do it right. Because none of us like to feel that we have to plan out every day, every moment. It's not always a great feeling. But it is the second most important thing I'm going to have you do to pass this bar. Because I want you to commit to what you're going to study, when you're going to study it, so that we don't get to 10 days before the bar and there's 4 subjects still you haven't memorized. And we don't, and this schedule that you're doing, the end game is the topics have to be outlined, if you're outlining, memorized and applied, multi-states done, the subject finished before the simulated exam in that area of the law. That's the end game. So you're going to take the simulated exams and the class schedule, and you're going to schedule your time. And you're going to schedule time off. Because you can't study 12 hours a day. It's not healthy. You can't study 10 hours a day. If you're a repeat taker, it should be about 8 hours a day. If you're working full-time, it should be 3 hours a night, 4 nights a week, and as much time on the weekends as you can get. First-time takers have more study time to do. Repeaters, it's less about studying the material and more about memorizing, applying, seeing how it's tested, writing out answers. These study schedules, and I want you to remind me, they're due, upload it through Moodle Saturday. Now, we're going to look at them, we're going to give you feedback, and we're going to make suggestions. The study calendar, if you're going to hand do it on a big old-fashioned calendar, should be in pencil. Your study calendar can be on a computer calendar like Office, Microsoft Word, whatever. And I believe that we have a sample template on Moodle that allows you to fill it in. We give you a calendar, okay? But I need it for the next, between now and 10 days before your bar exam, okay? Good question. The question is, what are the last 10 days? The last 10 days before the bar are review, cut sheets. What I'm going to have you do once you're done with all your studying is take each subject, use the table of contents in the approach book, and have a 2 or 3 page check sheet. Because you've studied everything, you've got all the content, now you need to walk into the bar with a 2-page list. So it's called a cut sheet. So the last 10 days is to clean up anything you didn't do completely well. It's to do a cut sheet of each subject. So there's 14 subjects. You would probably do like a cut sheet a day, 2 cut sheets a day per subject. So let's say 10 days for the bar, you have 1 day where you do your list for torts, 1 day you're going to do your list for contracts, real property, con law. It's also the last 10 days a cleanup time. Let's say you got a late start. Let's say you struggle with a subject and you may need to spend more time on it. Let's say you've gotten exam feedback from us and you have had lower scores in a particular subject. You want a couple days to review that. We don't want you smack up to the bar exam the last second. Study calendar. Always for class, what is due as homework are the questions that we're going to review in class for the next class. Those questions are on Moodle, and it gives you what's due. And as our class mentor said, the in-class questions are due for the next class. So we assign them tonight. The subject is due for the next class. So for example, tonight we did torts. The next class is going to be contracts and remedies. So the questions assigned for you tonight are due for the next class. They're always due before that class. Okay? Also, so you have study calendar, you have the in-class homework assignment that you need to prepare for the next DVD or the next live class, and you also need to meet, if you're in the live class, with your study partner to go over study group questions. If you're in the online course, doing some of the home study questions. That's because I want you always being in a dynamic format where you're learning, memorizing, and applying. You look at negligence, you pull out this question, and you look to see how they test negligence on an actual question. You're always outlining, memorizing, and looking to see how they test it. For the in-class questions for this class, you may do them open book. We're not testing you right now. We want you to get the approach, the format, the structure. Our simulated exams are closed book. So by the time you get a simulated exam, that material needs to be reasonably memorized. Yes, there's a question. Go ahead. No. Your in-class homework assignment questions do not get uploaded to Moodle. Your study group questions do not get uploaded to Moodle. Your in-class questions are for preparation for the class. If you don't do the in-class questions, the class isn't going to be as meaningful. You're not going to get as much out of it. Okay, that concludes our lecture for tonight. Thank you so much. So tonight we just did how to start studying, how to prepare a study schedule, a torts approach, how to outline a question in 15 minutes, how to prepare a study calendar. And you've been given your homework.